Thank you very much. I'd just like to greet my colleagues from Gauteng and thank all the media for coming here today for this very important press conference outside a court at which some very important cases are going to be heard this week. My job is to tell you what those cases are about and why they are important for every single South African. You've heard from Premier Windi why people in the Western Cape can look forward to energy security within 2 years. Load shedding will decrease systematically as our own generation continues and as alternatives to Eskom are put online through private power producers and small-scale embedded generation. But the DA cares about the whole country. We care about every place, even where the voters have chosen not to put us in government. Where they have, we can improve situations, and where they've put us into government for 15 years, as they have in the Western Cape, things can get dramatically better. But we will never ever give up on the rest of South Africa, and we are here in court today because our purpose is to ensure that the rest of South Africa is not left behind. Now, these crucial court cases are to ensure that responsibility for this crisis is acknowledged and laid where it must be, because that has crucial consequences. You've seen that load shedding is called economic collapse. Economic collapse causes massive unemployment. And in that context, the government still sees fit to raise the electricity tariff by 31.4% over 2 years in terms of the multi-year price determination. Now, we obviously could not sit back and allow that to happen. So we have done several things. The first of those things is to seek a declarator from the court that it is a complete violation of the human rights of South Africans to face this electricity crisis and the constant load shedding that it has brought with it. If you look at Chapter 2, the Bill of Rights of the Constitution, you will see that just about every one of those rights is violated by the electricity crisis in South Africa. And of course, it is the government's duty to defend people's rights. That is one of the most important duties of a government and a state, is to defend people's rights. And in terms of the president's own version of events, it was their failure to listen to and implement the 1998 white paper that we ended up in this mess. And the president has accepted that they are responsible. The ANC, Eskom, the government are responsible for the energy crisis in South Africa and for load shedding. But we need a declarator from court to confirm that and to say to all of South Africans, this is where the problem emanated: a failed government and a failing state. Now, that is important, not just to make the point, which is still important, but it is important because it opens the way for us to find the solution. You know that South Africa has an energy action plan, and we have absolutely no confidence in this government in being able to implement that plan. In fact, now, shortly after the appointment of a Minister of Electricity, we're at stage 6 load shedding for the foreseeable future, despite the fact that that same minister said the plan was working, which was why load shedding decreased. His words were not even cold, and we were in the middle of stage 6 again. So we have no confidence that this government is going to be able to implement its own plan or solve the problem that it created. And so, once we've had a declarator from the court, which we hope to get, that the crisis is a result of this government's failure when it had a duty to protect people's rights and protect energy security, once that has been declared, then we can draw the safe conclusion that the government is not able to resolve the problem without independent oversight. And so we'll be asking the court to appoint a special master, what in law is called a special master, to oversee, to regulate, to monitor the implementation of that plan. because then we will get an independent insight into what is happening. We will be able to believe the reports we are getting. The person appointed will have to have real expertise to do the job. We've got proposals in our court paper as to how we should go about that. And once we've got a person there who we can trust and who can do the projections into the future accurately, South Africa can prepare for the reality, not wishful thinking, not political hot air, and we can go into the future on that basis and hold government to account on that basis. The second critical part of our case, the first part was to declare this constitutionally incompetent or contrary to the Constitution. Incompatible with the Constitution is precisely the words that we've used. The next step is then to challenge the price increase. Now we are doing that on the basis of the fact that we believe Section 15(1)(e) of the Electricity Regulation Act has been misinterpreted, which means that NERSA has imposed a tariff increase without taking note of crucial data that it should have. Now, this is very complex in the court papers. I've read it through all very carefully, and I'll try and distill it for you. There are two stages in the tariff determination, the tariff price determination. The first step is the multi-year plan. It's a multi-year plan in which the electricity price is projected over several years. And the next stage is working from that, what's called the NERSA, the establishment of the tariff increase for the year. But what we have established is that crucial public participation was not done in the multi-year price determination phase, which meant that the cross subsidies to the poor were not adequately considered. We know that people cannot afford this 31.4% increase over 2 years, and we believe that if the data had been taken into account, this increase would not have been put on the table. And because the crucial public participation phase was omitted, that data was not taken into account of the impact on the poor, and we are asking for NERSA to be able to go back for a period of 6 months and remedy that failure and come back to us with a redetermined price that is more affordable because it takes subsidies into account and it takes public participation into account. So our case is based on two legs. One, declaring the government's actions as inconsistent with the Constitution and therefore needing to appoint a special master who will report to the court. And number two, establishing and instructing NERSA to go back and redetermine the electricity price increase, taking the proper data into account. Those are our pleadings before this court, and if we succeed, it will be a massive victory for poor South Africans and for South Africans everywhere, not just in the Western Cape. Thank you.